Imagine receiving a notice from the Registrar of Companies, not because your company committed fraud, not because investors lost money, but because you accidentally missed a procedural filing. Could that simple mistake expose directors to criminal prosecution? For years, thousands of companies, LLPs, and professionals have faced criminal proceedings for technical and procedural non-compliances. But now, the government is planning one of the biggest overhauls of India's corporate law framework. The Finance Ministry, the National Financial Reporting Authority, and a Joint Parliamentary Committee have started examining the Corporate Laws Amendment Bill 2026 *. Will imprisonment for many procedure and defaults finally disappear? Will penalties become more rational? Will compliance become easier for companies and LLPs? Or are even stricter governance norms coming? Stay till the end because I'll explain what the bill proposes, why it matters to every corporate professional, what may change under the Companies Act and LLP Act, and how these reforms could reshape corporate compliance in India. Let's begin. Corporate law in India is constantly evolving. Every amendment attempts to strike a balance between two competing objectives: protect investors and promote ease of doing business. The proposed Corporate Laws Amendment Bill 2026 seeks to modernize India's corporate governance framework while reducing unnecessary criminal consequences for technical defaults. This proposal could significantly affect companies, LLPs, directors, auditors, company secretaries, chartered accountants, cost accountants, and other compliance professionals. What has happened? The Finance Ministry and the National Financial Reporting Authority, NFRA, recently briefed the Joint Parliamentary Committee examining the Corporate Laws Amendment Bill 2026. The committee is gathering views from regulators, professionals, industry bodies, and stakeholders before finalizing its recommendations. This means the legislative process is actively underway, but the proposed changes are not yet law. Why is this bill important? Here's the biggest question. Why does India need another Companies Act amendment? Because over the last decade, many procedural defaults attracted criminal consequences, even when there was no fraud, no public loss, no dishonest intention. Industry consistently argued that criminal prosecution should focus on serious misconduct rather than technical lapses. The proposed bill seeks to address this concern. What is decriminalisation? This is perhaps the most misunderstood legal term. Decriminalisation does not mean legalization. It does not mean companies can ignore the law. It simply means that for certain specified procedural defaults, the consequence may shift from criminal prosecution to civil or monetary penalties. For example, instead of facing criminal proceedings before a court for a procedural lapse, the company or its officers may be liable to pay an adjudicated monetary penalty, wherever the amended law provides. Serious offences involving fraud, public interest, investor protection, or intentional misconduct are generally not intended to be treated in the same manner. What may change? Although the final legislation is awaited, the bill broadly seeks to simplify compliance under the Companies Act, amend the LLP Act, rationalize penalties, reduce criminal prosecution for specified procedural defaults, strengthen corporate governance, improve regulatory efficiency, promote ease of doing business. These objectives indicate a shift toward a more risk-based and compliance-friendly framework, while retaining strict action for serious violations. Why is the LLP Act also being amended? Many startups and professional firms prefer the LLP structure because of its flexibility. The government intends to modernize the LLP framework as well, making it more aligned with current business practices and reducing avoidable procedural burdens. What does this mean for company secretaries? This amendment could significantly influence the work of company secretaries. Compliance manuals may require revision. Board processes may change. Secretarial checklists may need updating. Internal compliance systems may have to be reviewed. Every company secretary should closely monitor the progress of this bill. What about directors? Many directors worry that even technical filing mistakes can lead to personal exposure. If procedural defaults are increasingly dealt with through adjudication and monetary penalties, where the amended law so provides, governance may become more proportionate, while directors will still remain accountable for serious violations. Good governance will continue to be essential. What about auditors and NFRA? The involvement of NFRA highlights the continuing importance of audit quality, financial reporting, and corporate governance. Although this bill focuses on broader corporate law reforms, regulators remain committed to transparency and accountability in financial reporting. Important caution. One important point must be clearly understood. This is presently a bill, not an enacted law. The Joint Parliamentary Committee is examining stakeholder feedback. The proposed provisions may be modified before Parliament passes the legislation. Only after enactment and notification will the amendments become legally enforceable. Why this matters to every business? Whether you operate a private company, a listed company, an LLP, a startup, or a large corporate group, these reforms could affect compliance costs, regulatory procedures, penalty exposure, corporate governance, board responsibilities, annual compliances, professional advisory work. Key takeaways. Corporate Laws Amendment Bill 2026 is under parliamentary examination. Companies Act and LLP Act are proposed to be amended. Focus is on ease of doing business. Minor procedural defaults may increasingly attract monetary penalties instead of criminal consequences, where the amended law provides. Corporate governance reforms continue to remain a central objective. Final provisions will be known only after Parliament enacts the legislation. India's corporate regulatory framework is entering another important phase. The objective is not to reduce accountability. The objective is to distinguish between genuine fraud and technical non-compliance while preserving strong corporate governance and investor confidence. For every company secretary, chartered accountant, cost accountant, director, and corporate lawyer, this is one of the most important legislative developments to watch in 2026. If you found this analysis useful, please like this video and subscribe to * Corporate and Securities Law Compass. In the next video, we'll examine the * Corporate Laws Amendment Bill 2026 clause by clause, compare the existing provisions with the proposed amendments, and discuss their practical impact on companies, LLPs, and compliance professionals. Thank you for watching. Disclaimer. Viewing this video or accessing the content on this channel are free and does not create any professional, advisory, or client relationship between the speaker and the viewer. The content is shared solely for general educational and informational purposes. The speaker is a member of the Institute of Company Secretaries of India, ICSI. However, the information provided in this video should not be construed as professional advice, consultancy, or opinion under any law or regulation. Viewers should not rely solely on the information provided in this video for making legal, financial, regulatory, or compliance decisions. Any person intending to rely upon or act on the information contained herein should independently verify the relevant provisions of law and, where appropriate, seek professional advice from a qualified professional. The speaker, the Institute of Company Secretaries of India, ICSI, and any organization or listed company with which the speaker may be associated shall not be liable for any direct or indirect loss, damage, or consequences arising from reliance on the information provided in this video or channel. The content shared on this channel is based solely on publicly available information, general legal provisions, and academic discussion of corporate and regulatory frameworks. The speaker confirms that no unpublished price-sensitive information, UPSI, confidential information, or proprietary information of any listed company or organization has been disclosed or discussed in any video or content on this channel. The views expressed in the videos are personal academic interpretations for educational purposes only and are not connected with or derived from any confidential information obtained through employment, professional engagement, or association with any listed company or organization. Nothing contained in this channel should be interpreted as market advice, investment advice, or insider information under the applicable provisions of securities laws, including the SEBI Prohibition of Insider Trading Regulations 2015. Viewers are advised that the information shared is purely for general educational awareness and should not be relied upon for investment decisions, trading decisions, or regulatory compliance without consulting appropriate professionals and official sources.